it's a rare victory for gun restrictions from this court. Remember, this is the same court that just 2 years ago, in an opinion written by Justice Thomas, a 6-3 opinion, said the Second Amendment should be interpreted today the way it was publicly understood by the ratifiers in 1791, when there were no domestic violence restrictions. So here's the issue this morning. The defendant here pulled a gun on his girlfriend, but the government decided for a variety of reasons not to prosecute him. So there's no conviction for the improper use of the gun. But because they were living together and because she was fearful it might happen again, she filed a domestic violence action against him. And the court said, look, you can still live together, but we're going to take the gun away from you for a cooling off period. Not forever, but for a cooling off period. He challenged that. That's the challenge that came to the court today. The majority said, well, yes, you should look at the law today as it was historically understood, but historically we have always protected people from those we deem dangerous. Justice Thomas said, oh, no. You can't just take a gun away from somebody because he's deemed dangerous. He hasn't been charged or convicted of a crime. But it's an 8-1 majority, so that statute stands. Justice Thomas fears the use and abuse of that statute by local authorities who don't want people to have guns.
I see. We've got some of the majority statement here, authored by Chief Justice John Roberts, saying, quote, when a restraining order contains a finding that an individual poses a credible threat to the physical safety of an intimate partner, that individual may, consistent with the Second Amendment, be banned from possessing firearms while the order is in effect.
What he should have said was consistent with the history of the Second Amendment, because the history of the Second Amendment, according to Justice Thomas, who's the Second Amendment guru on the court, goes the other way. The history of the Second Amendment is there's no interference. So I'll give you an example. President Trump, because of the conviction on the bookkeeping falsification, loses his right to carry a gun and has to surrender all of his guns. There's no connection. So Justice Thomas's fear is that we will see more of these cases. A simple allegation of domestic violence, as opposed to proof of guilt beyond a reasonable doubt, results in the loss of a fundamental liberty, the right to keep and bear arms.
And that's what I wanted to bring up with you, just kind of really hone in on this point. I've been going through just how the news has been headlined when that ruling came out. I thought Politico did the best job, and that's an opinion that I'm sharing here. But this is exactly what they said, what they wrote. Alleged domestic abusers can't own guns, Supreme Court rules. Cut, simple, to the point. But a lot of the news outlets right now are leaving out that point, the alleged part.
Correct. And the alleged is what's dangerous, because the Supreme Court has said consistently since the Heller case by Justice Scalia in 2008, the right to keep and bear arms is a fundamental liberty. It precedes the government. It doesn't come from the government. It comes from our humanity. How can you take that right away on the basis of an allegation? That's the dissent. But this is an overwhelming case. Justices Alito and Gorsuch are fierce defenders of the Second Amendment. They went along with the majority on this.
One more thing I mentioned at the top of the show was about how this could be linked to Hunter Biden's case, the challenge to have his rights to the Second Amendment. Do we have any sort of idea how the Supreme Court would view the challenge that you would want someone who had been a drug abuser to have?
If this case had gone the way Justice Thomas wanted it to, it might have invalidated the prosecution of Hunter Biden, but it didn't go that way.
Yeah.
Another one here today really quickly is the immigration-related one that was handed down earlier today at a 6-3 ruling. The Supreme Court ruling citizens do not have a constitutional right to challenge the State Department denying a spouse visa applications. Justice Amy Coney Barrett writing, quote, on the premise that the right to bring her non-citizen spouse to the United States is an enumerated constitutional right. To establish this premise, she must show that the asserted right is deeply rooted in this nation's history and tradition.
So what Justice Barrett is saying, that the right, she's not talking about the right to get married.
Right.
She's not talking about the right to marry someone who's here. She's talking about the right to take someone who's not here, jump over the line of those who are waiting so that that person can get married. There is no history or tradition of that. So that's why the Supreme Court upheld the ban on that person's visa. State Department didn't say, you're never going to come in. State Department said,